Good morning. I'm extraordinarily pleased to be back here at Utah Valley University. Many years ago, I had the chance to talk at length with then President Matthew Holland about the idea of a Center on Constitutional Studies here at UVU. And I've been back to participate after it was created, and I've had many conversations with Scott Paul as he's been helping shepherd the center through its next stage of growth. This is a terrific program you have here. I don't know if there's any benefactors in the office, in the room, but if there are, this is what's going on here is extraordinarily important, and it's a pleasure for me to be a small part of it. I should also mention I have all sorts of UVU swag because my niece used to be the assistant volleyball coach here up until a few years ago. Much to my regret, she left, but I have family here in the area, and I'm from the West, and it's just beautiful here. So I'm always happy to return. Let me congratulate Professor Brogdon on the appointment of the Miller family directorship. Is that right? I mean, it's a wonderful hire to bring Professor Brogdon here, an accomplished scholar. You've also brought a former student of mine, Rob Burden. I don't know where Rob went. He is a terrifically thoughtful young man. And I'm so pleased that he's here, bringing some of the things he learned at Notre Dame here to Utah Valley. So I can't say it's exactly a homecoming, but I feel very at home here, and I'm pleased to be with you. Okay, I thought I might start with a story here about one of the first major Supreme Court cases on the free exercise of religion. The case is Reynolds versus United States. Maybe you know it. It was actually involved a federal law banning bigamy and polygamy in the federal territories. George Reynolds was, I believe, a secretary of Brigham Young. And George Reynolds was asked to take a second wife. As you all know, Mormons practiced polygamy then. Of course, don't now, but it was the practice then. So he did so, took a second wife in violation of federal law. He was arrested, fined. I think the fine was $500, and sentenced to 2 years hard labor. I mean, you might have thought the act of having two wives is hard labor enough, but I leave that alone. So he filed a lawsuit and said the First Amendment protects the free exercise of religion, clearly practicing a religion. Second marriage is clearly a religious exercise. I have a constitutional right to engage in this behavior and thus to be exempt from the federal law prohibiting it. This is the first major case that gets to the Supreme Court on the free exercise of religion. And the Supreme Court said, when trying to understand and interpret the free exercise of religion, the word religion is not defined in the Constitution. We must go elsewhere, therefore, to ascertain its meaning. And nowhere more appropriately, we think, than to the history of the times in the midst of which the provision was adopted. And then they cite Thomas Jefferson's letter to the Danbury Baptist Association. Now, whether or not the court, and this is the passage, the relevant passage they cite from that letter. Now, whether or not the court should have turned to Jefferson, with these few sentences, the court engaged in an originalist approach to interpreting the First Amendment, approach that still guides the court today. This is true of conservative justices, but also liberal justices. Everyone is an originalist, at least in this manner of the law. Even non-originalist opinions themselves are developments of originalist opinions. Okay? Now, the Reynolds court found that George Reynolds did not have a constitutional right to be exempt from the federal bigamy law. And the court cited what's known as Jefferson's belief-action distinction. Jefferson says, your beliefs are protected, but not your actions. And that gave a way for the court to dispose of the case at hand. But that doctrine, the belief-action doctrine, really, if you think about it, is not, well, one, it doesn't square with the text of the Constitution, which protects religious exercises. And analytically, it's not very useful. So that doctrine would soon fade away. But the turn to the founders would not. In fact, in 1947, in its first major Establishment Clause case, the court cited the same letter. This is the Wallace separation letter. And the Reynolds precedent from the 19th century becomes the 20th century precedent by how we get the idea of a wall of separation between church and state. And that precedent was used in the 1960s to eliminate prayer in public schools, prevent Catholic schools in particular, or religious schools from receiving federal funds. In the 80s, conservatives started to push back against this approach. But again, everyone is an originalist, and everyone says we ought to turn to the founders to understand the First Amendment. Being a typical scholar, I think everyone is wrong. No one understood anything until me. This is what we learn in graduate school. So this book I just published attempts to try to do three things. It provides a constitutional history, try to explain what we can and cannot determine about the original meaning of the religion clauses. It explains the founders' constitutional philosophy. And here I try to document and set forth the founders' articulation of religious liberty as a natural right. And then, as was mentioned, I present a constitutional construction. If we take this constitutional philosophy of the founders and applied it to the First Amendment, what kind of jurisprudential results would we get? I should say my aim is really not to defend the founders. It's not a normative work in the sense of saying that we ought to go back to the founders. My argument is a little bit different. It is, if we are going to go back to the founders, we should at least get them right. And we can't evaluate whether we should or should not go back to the founders until we understand them. I mean, perhaps we should go back to the founders because they're wise and prudent, but we can only make that judgment when we understand them. Or perhaps we should depart from the founders because they're not relevant to our times or their principles were wrong, but we can't make that judgment either until we understand them. So if I do my job well, I'll have my readers be in a position where they can judge for themselves whether they should follow the court and go back to the founders. So I'm not trying to defend the founders, just present them. Okay, so let me just, it's a long book, so let me just try to summarize a few of the highlights and then develop one small argument in the book. I'm going to start with the middle part of the book, which should you read it, I didn't tell Professor Peacock and Professor Hancock this, but I'll tell you, should you buy the book, just skip the middle part. It's written for lawyers, which means it's really detailed and boring.
Now you tell us.
It's really long as well. And what I do is I go through the drafting record of the First Amendment. Now, a scholar needs to do this because that's what the court has done. And Supreme Court justices and Supreme Court opinions have gone through the drafting record. And they go through the drafting record and they say it means strict separationism or accommodationism. Well, I went through the drafting record and my findings are a little bit different. My findings are, if you really go through the record carefully, you really can't determine what the original meaning of those words were. And I have a whole story of why that is. And I could come back to that in the Q&A or in our discussion if you want. The simple story, though, is the people who drafted the First Amendment did not think it was necessary. And therefore, they were eager to draft. It's kind of like when you want your kids to be satisfied and go away. You say things that satisfy them, it's not that you don't mean them, you're just not especially careful with your words. And that's true of actually the drafting of the First Amendment. Let me just say, again, the people who actually drafted the First Amendment, the Federalists, didn't think the First Amendment was needed. It was the Constitution's critics, the Anti-Federalists, who wanted the amendment. But the Federalists dominated the first Congress. The first Congress drafted the First Amendment. And they just wanted the Anti-Federalists to go away. And so one of the reasons why we've struggled to understand the original meaning is because there's no clear original meaning there. So then what do? Where do you go? Well, the founders did talk about religious liberty quite a bit. This is George Washington, I think the most beautiful letter, or at least one of the most beautiful letters in American history, George Washington's letter to the Hebrew congregation at Newport, Rhode Island. When the founders talked about religious liberty, they said it was a natural right. So we have to, if we want to understand the founders' approach to religious liberty, we have to try to understand what is a natural right and what is the natural right of religious liberty. Even that's a little bit more complicated because there's two types of rights and then there's two types of natural rights. When we talk about rights, there's natural rights and then there's what the founders call as acquired rights. Natural rights you have on account of your human nature. Natural rights are endowed by the Creator. They're not granted or created by the government. We institute government to protect our natural rights. There are things we possess that government must respect. Acquired rights are rights we acquire by being a part, the right to vote or the right to serve on a jury. Because you're a citizen, you have this right, but it's not a natural right. Okay. So first simple distinction, natural rights and then non-natural or acquired rights. Second distinction, the founders talked about alienable natural rights and inalienable natural rights. And this language is familiar to us. We talk about inalienable natural rights all the time. And if you ask, I should do this right, what work does the word inalienable do? People are like, maybe that means it's really important. Well, inalienable actually has a precise and technical meaning. I mean, the obvious answer is, well, an inalienable right is different from an alienable natural right. So we have to try to understand what an alienable natural right is. And we have to understand this distinction if we want to understand the founders, and we want to understand the founders because we want to apply their thought to the First Amendment. Everyone with me here? Okay, so let's try to figure out what's an alienable natural right. This is the one thing I thought I'd do in detail. These are actually my children. And I'm going to use an example. One of the students liked this. I was talking to him this morning, so I'm going to try to use this example. Okay, you have a natural right to acquire property, right? Why? Because you own your own labor, right? So if you go fishing, I don't know, can you fish in the Great Salt Lake? Are there fish there? Yeah, there's a lake right here, right? So in between here and Eagle Mountain. Can you fish in that lake? You don't want to do that? Okay, you're fishing in the Provo, and no one owns the Provo River? Does BYU own the Provo River?
I think it must.
Yeah. So you're fishing in the Provo River, and if Professor Hancock catches a fish, whose fish is it? It's his fish. Why? He pulled it out. So if he gets the fish out of the river and pulls it out, puts it on the shore, and I go and I take the fish, is it my fish? Well, why not? He pulled it out of the river. I pulled it away from him. And just look at us. He's not going to try to take it back. So why is it his fish? Who said so? Oh, I did the effort too. First I pushed him away and then I had to take it. Okay, tell me your name. Lydia says, Professor Hancock took it from Nature and I took it from Professor Hancock. And I say, yeah, Lydia, that's an accurate description. And there's nothing Professor Hancock can do about it. But you all think it's his fish. Why is it his fish? I'm stealing from him, right? I'm stealing his fish. But what am I really stealing? His effort, his labor. Professor Hancock owns his labor, right? We all own our own labor. Well, why does Professor Hancock own his own labor? Who said so? I mean, every kid knows this, right? Finders, keepers. Like, you don't have to teach kids this. They just know it. But why? Why is that true? We think it's a principle of justice. Yeah, because it's a natural right. We own our own labor by nature because that's the type of beings we are. That's what I mean by a natural right. So when I take Professor Hancock's fish, I'm stealing his fish, but really what I'm doing is stealing his labor. And if you categorically steal someone's labor and you own all their labor, you have made them a slave. So when we say all men are created equal, we mean every individual, every human being by nature, as created by our Creator, owns their own labor. And therefore slavery is unjust because it's the theft of someone else's labor, it's of their livelihood. Everyone follow me? That's what a natural right is. That's a natural right to acquire property. Okay. Now, what are the limits of the natural right to acquire property? Well, you can't take more than you can use, can't spoil, and you have to leave enough for others. Okay? Every natural right has natural limits. Okay? So what happens when Professor Hancock takes too many fish? Who enforces the law of nature? Anyone and everyone, as my children are explaining. Right? So I'm going to go over just a few minutes. We create government to protect our natural rights. And so the right to acquire property is an alienable natural right. When we don't give up the right per se, we give government, we create a government, we grant it power over. So then the government says you can catch this many fish, right? Using these methods. We regulate fishing. And we regulate fishing, we regulate our natural rights to protect them. So everyone can enjoy the right to acquire fish. The purpose of government is to secure our natural rights. And we empower government to do that. Everyone follow me? This is all standard American political thought. If that is what an alienable natural right is, what is an inalienable natural right? It's a natural right, the gentleman says, a natural right that cannot be regulated by government because we do not give government that sort of power. Everyone follow? You just saved yourself 300 pages of reading. Okay? This is how we can picture it. We grant government all sorts of authority, but we also withhold authority. For example, our right to revolution is a natural right, and it's an inalienable right, because we can't give government the power to regulate the right to revolution, right? I mean, you can have a revolution license. You can do it on Tuesdays and Fridays from 3 to 5 p.m. It's nonsensical. The founder says religious liberty is an inalienable natural right. This is the foundation of limited government. There are some things government can't do because we never gave government that power. Let me give you a simple example that gets at the heart of the argument of the book. The state of Utah, I'm sure, issues licenses for everything. If you want to fish, you got to get a license. If you want to be a grade school teacher, you got to get a license. If you want to be a doctor, you have to get a license. If you want to cut hair, you have to get a license, right? And we do that to facilitate the acquisition of using your talents, but also to protect the public. Could the state of Utah issue preaching licenses? If you want to preach the word of God, you must get a license from the state. And we say no, why not? Because there are some powers government doesn't have. It would be improper because the role of government is not to say who is and who is not a legitimate preacher. We retain that judgment for ourselves. That's the essence of the founder's teaching. Okay? Now, what the book does, this would be the core argument. There are certain things government can't do. It can't punish you for practicing your religion. It can't punish you for not practicing a religion. It can't license ministers. It can't tell you what to believe or not believe in the matter of religion. What the First Amendment was meant to do, or at least if we interpret the First Amendment in light of the philosophical principles of the founders, it would be a relatively narrow protection, but it would be a categorical protection. It would remind government there are certain things it cannot do. And it cannot do it because we, the people, never gave government that authority. And let me just say one more word here. The reason why we do not give government the authority over our religious opinions and our religious actions is because those opinions and actions are an obligation we owe to our Creator. And we can't outsource that obligation to the government. We're responsible to our Maker for our religious beliefs and practices. That's why we limit government. And what the book tries to do is explain what that would mean constitutionally. All right, thank you very much.
All right, well, my thanks to Matthew, to Robert Burton, as well as everyone else at UVU's Center for Constitutional Studies for inviting me to participate in this conference on the First Amendment. I think it's both interesting and timely, and I'll try to explain why I think that's the case. But I'd also like to thank Phil and Ralph, who are good friends and good colleagues going back a generation. So thanks to Matthew for, to some extent, facilitating a reunion of sorts. And also thanks to all of you for coming out. Many of you know I teach up at USU. I'm the director of the Center for the Study of American Constitutionalism up there. And we don't have anywhere near the kind of center that you have here. This is a great facility, as Phil mentioned. I think it's a great project here at UVU, and it's great to see all of you out here that are interested in these issues today. First, let me commend Phil. I'll use first names here. I'm very monosyllabic and have very difficult time saying Professor Muñoz or Professor Hancock, and it's a little more friendly. It's just Phil and Ralph. But let me commend Phil on a very fine and provocative book. Like Phil, I'm concerned about maintaining the founders' natural rights constitutionalism. It's largely what I do as an academic. I'm an advocate in that sense, and I appreciate what he's doing here. And I also more generally appreciate the principles of classical liberalism that I think are the foundation of American constitutionalism, that can be traced not only back to the minds of our own founders like Alexander Hamilton, John Jay, James Madison, who wrote the Federalist, but all the way back to Greek and Roman antiquity. And I think, as Phil indicates in the introduction to his book, American and Western civilization are largely under attack these days from both elements of the left and elements of the right. And I think Phil does a very good job of outlining that fundamental, if you want to call it scholarly, cultural, political problem in his book. And he defends the natural rights constitutionalism of the founders, I think, very well. And also the moral order that I think is at the base of that constitutionalism that I think Phil alluded to in his lecture. I think I've got 15 minutes here. I forgot to time myself just to make sure. If I go over, Matthew, just, feel free to stick out the cane and yank me away. And I think that that's an important aspect of the book, is that there's a foundation in American constitutionalism that's moral in nature, and that's the basis of our form of government. But as Matthew indicated at the outset, our role here today, Professor Hancock's and mine, is to be a critic. So I'm going to play the role of the devil's advocate here, and Phil and Ralph both know how much I like to play the role of the devil. So here's my shot at it. These are some of the questions I have about Phil's book. My first question is this, Phil. On the very first page of your preface, as well as in the introduction, excuse me, you contend that you are not advocating for the implementation of the founders' natural rights constitutionalism or adoption of a natural rights jurisprudence of religious liberty. Since that's beyond the scope of your book, you say, and I quote from your preface here, that you are sympathetic to some aspects of the founders' constitutionalism, but at the same time, you don't favor some of the results its implementation could produce, at least when it comes to the founders' natural rights constitutionalism. Can you pick and choose what to implement and what not? My own interpretation is that I think it's a package deal, and picking and choosing might lead to a certain arbitrariness, especially when it comes to judicial construction, which I'll get to in a moment. More fundamentally, why not advocate for the implementation of the founders' natural rights constitutionalism? You indicated in your presentation that you're not really here to defend the natural rights constitution so much as to explain it, and I can appreciate that. But I get the impression in the latter chapters of the book that that's very much what you seem to be doing. You say in the introduction that you want to remedy our intellectual amnesia. Again, I'm quoting there. when it comes to understanding religious liberty and the inherent and inalienable natural right to religious freedom. I guess my question is, what's the point of doing this if you don't think this should be implemented constitutionally in, say, case law? And I'll mention some of that again here in a minute. You say that early cases, and you mentioned the Reynolds case from 1879, the Everson case, the separation of church and state case from 1947, brings us back to the founders' understanding of the Constitution, and has done so ever since. The Supreme Court has done this ever since these cases. But it has done so, I think, the way you explain it in the book, and I think very compellingly, in a very muddled way. So I guess the question is, why not be a little bit more of an advocate of this form of constitutionalism? You say you don't agree with progressives who believe in who believe that the founders' thought is outdated because it's old, or perhaps because it's just a bunch of racist white men who owned slaves who created it. But you also say that you're not inclined to agree with the originalists who follow tradition because it is old, because it's not the same as the good. Natural rights constitutionalism is presumably about precisely that good. So again, can you clarify what exactly the judicial philosophy is that you think the court should follow? Because as constitutionalists, we have to come up with an opinion about these sorts of things. The other point I want to raise, somewhat related to that, is that like our mutual friend Hadley Arcus, we all know Hadley, who you mentioned in your acknowledgments, and who wrote a very fine book in 1992 called Beyond the Constitution. You too contend that you have to go beyond the Constitution because the original meaning of the First Amendment's religion clauses were left ambiguous by the framers. We must go beyond the text, as you say, of the Constitution to construe those clauses to establish their meaning. And I think this is perhaps the most problematic part of the book. It's problematic for a number of reasons. First, critics will say that there is no such thing as a coherent natural rights philosophy, that a natural rights constitutionalism is largely simply a ruse for imposing an academic's or judge's personal preference under the pretext of natural law or natural rights. This was the accusation against Hadley Arcus's book, that if the Constitution is based on some sort of moral order beyond the Constitution, why do you need a written Constitution in the first place? If you're just appealing to right reason or what is right by reason, then why do you need any kind of a document there in the first place? You allude to that problem, I think, in Chapter 4, where you discuss expansive liberals, what you call expansive liberals, and narrow Republicans, who, as you note, understood their own positions to be compatible with the natural right of freedom, but disagreed on the scope of that right, especially about the extent to which that right limited democratic governance. In your conclusion as well, you talk about the natural rights constructions too elastic, and you mention that doctrinal rules alone can't guarantee their good faith application, and you cite Michael Stokes Paulson, for instance, who contends that the judiciary should not enforce undetermined text like the religion clauses and should defer to the constructions of the political branches of government with these. And your response to that is a good one, but I don't know if it's adequate. That is that the Constitution is supposed to govern, and you want to get to the meaning of the Constitution, but I'm not sure that gets around the objection. Also, in your conclusion, you talk about the need to adopt natural rights constructions only for the religion clauses. Is that problematic? Because you've got a fairly categorical interpretation of the religion clauses, because as Matthew cited the First Amendment at the outset of our panel, the First Amendment was very categorical that Congress shall make no law. But that also applies to free speech and free press, as you note, and we have lots of qualifications for those: obscenity, libel, things like that. So why can't that apply to the religion clauses as well? And also, I just want to commend you. I don't want to be completely critical. You do a very good job tying Locke's political philosophy to Jefferson's political philosophy in Chapter 3. It's very interesting stuff. Just a couple things more about the idea of your natural rights constructivism. You call entering, so Professor Muñoz's argument is that the meaning of the First Amendment religion clauses is ambiguous. It isn't perspicaciously clear. And because of that, you have to really go beyond the language of the clause or the clauses to interpret their meaning. And this is what's called constructivism. And I guess the concern that I have, and you cite people like Lawrence Solomon, Thomas Colby as sources here, is that for people like Colby, by definition, constructivism supplements interpretation and cannot be dictated by it. So how do you avoid the accusation of arbitrariness when it comes to that? And also your design originalism that you develop towards the end of the book as well, may be subject to the same sort of thing, that a skeptic might contend that the natural rights constructions that you provide are really just juicy rationalizations for your own political preferences. And let me just end with, because I think I'm just about out of time here, let me just end with a comment or two about the case law that you cite in Chapter 8. And this is titled, for those of you who are looking to find this in the book, How the Natural Rights Constructions Would Adjudicate Actual Cases. Even if you accept the constitutional construction that you set out, as you point out in that chapter, people might differ on the results. And I think that's, an honest assessment. But is that, again, problematic just because it shows the potential arbitrariness of this? And the one example that I would give here, since I'm a little short of time here, is the exemptions idea. All right, there's a constitutional jurisprudence, particularly most recently and perhaps most famously, Employment Division versus Smith, that argues that the religion clauses are of a higher order than other sorts of liberties in the Constitution. And because of that, there should be some sort of exemptions for otherwise generally applicable laws to accommodate certain types of religious practices, which Professor Muñoz is opposed to, that there shouldn't be those sorts of exemptions. But as you know, Justices Alito, Thomas, and Gorsuch in Fulton versus City of Philadelphia, in their concurrent opinion there, rejected that. And Mike McConnell, who some of you may know, was a law professor just down the road here at the U. He was on the 10th Circuit Court of Appeals as well. He's probably the most famous advocate for the exemptions doctrine. Should we accept Justice O'Connor's opinion where she says that the First Amendment, and I'm quoting here, occupies a preferred position and that the court will not permit encroachments upon this liberty, whether direct or indirect, unless required by clear and compelling governmental interests of the highest order. And she identifies this with race discrimination. In constitutional law, if you discriminate or you have race classifications in law, you're subject to strict scrutiny. And what she says is that the religious classifications, which the Free Exercise Clause in the First Amendment and the Establishment Clause protect as well, are of a higher order of liberty or rights, inalienable rights, that require more protection than other sorts of liberties. And that failing to do that with this idea from Smith that just generally applicable laws are all you need to do is really a violation of the meaning of those clauses. And I appreciate some of you may not know some of these legal distinctions, and I'm getting a little bit into the weeds, but I think that that's one of the problems with the doctrine. But otherwise, I think it's a very fine book, very good read. I highly recommend it. I commend chapters 3, 7, and 8 in here as probably the most interesting. I would have liked the warning earlier about not reading the middle part of the book, although that was pretty interesting too. Maybe not as interesting as the front end and the tail end, but very much appreciated the book. So thank you, Phil, and thank you all for being here. I'll pass the floor over to Professor Hancock.
Good morning. I too am very pleased and honored to be here. Thank you. Particularly alongside my friends Phil and Tony. It's an honor to be here and to participate in this event sponsored by your Constitution Center, which I admire, I must say, from a vantage point a few miles across town. I might even envy it a bit, but congratulations and thanks for including me. I think the panel is working out to be well balanced in a certain way, because I'm going to do another kind of work than what Tony just did. I'm going to pick up the question more from the philosophical side, and it is a challenge to engage Phil in this discussion, and at the same time engage you and address questions in a way that will be useful to you. But let's see. That's always the challenge, I suppose. Let's see what I can do there. Unlike Tony, I'm going to accept the necessity of constitutional construction, disciplined and constrained as it is, according to Phil. But I'm going to address the question of the philosophical standpoint from which that construction would have to operate. I'm going to disagree with Phil at the philosophical level, though I agree with him for the most part on his practical judgment, if I may say, and constitutional wishes as far as I understand them. Early in democracy in America, Alexis de Tocqueville comments on the general situation of religion and self-government, the spirit of America with respect to religion and self-government concerning American democracy. In doing this, he's, of course, contrasting the favorable American situation with the disaster that is the French Revolution and the enmity between religion and freedom as it appears in France. Tocqueville refers, I think, in words that bear very deep reflection. Tocqueville refers to the marvelous combination in America of the spirit of religion and the spirit of freedom. This combination is marvelous. Therefore, I would say rare and probably fragile. What Tocqueville finds in America might be described in the most compressed way as a religion-friendly natural rights republic. That's putting three distinct things together that are not necessarily easy to hold together. Religion-friendly, founded in natural rights, and Republican, based upon, we would say, liberal democracy, based upon popular participation as the final ground of authority. Well, Phil sees this American regime of religion, natural rights, religion-friendly natural rights republicanism, mainly as the result of the Revolution of 1776 and the written constitution making, state and national, that arose from that revolution. All this is reasonable and more than plausible as far as it goes. Further, he sees the First Amendment in particular as a product of the philosophy of natural rights, a largely Lockean philosophy that was widely shared in the early days of the American Republic. Phil's book is an excellent survey of the positions of significant actors in the founding, and moreover, I would say a bracing exercise in a kind of intellectual hygiene or constitutional house cleaning. His book clearly recognizes the mess we're in and makes a valiant effort to show how it might be cleaned up. The book is at once bold and modest, bold in proposing the clear doctrine of natural rights as a purifying agent in addressing our constitutional mess, and modest in recognizing the questions left unaddressed, such as the bearing of the 14th Amendment and the incorporation doctrine on this whole problem, and also the remaining indeterminacy, imperfection, and even the uncertain benefit of the pure natural rights solution. Since the full justiciable meaning, you might say, of the First Amendment with its two momentous clauses cannot be fully clarified, Phil argues, by reference to available founding documents and historical records, that meaning must be constructed. But this for Phil is a disciplined construction, constrained by, but not completely determined by, loyalty to the relevant texts, documents, and especially by the philosophy of natural rights. To construct this meaning, Phil proposes with admirable clarity, again, that we should favor the founders' theory, what he sees as a unified and determinate theory of natural rights, over the founders' own sometimes contradictory practices, such as their permission or favoring of legislative prayers would be one example. But really, the simple question I want to ask is, exactly why would we choose the founders' theory over their practice? Although Phil claims modestly not to be exactly recommending the theory, I would say that unless you are sure that the founders are in a possession of a clear and definite philosophy that is the comprehensive truth of moral and political things, unless you're sure of this, then you're not sure that the natural rights philosophy should be the foundation and touchstone of constitutional interpretation. Now, certainly the natural rights philosophy or rhetoric is a prominent and impressive feature of the founders' argument, but not the only feature. Professor Muñoz proposes to extract the natural right argument and make it the standard and the touchstone of everything else. The probity and wisdom of Phil's strategy would depend upon the probity and wisdom of the natural rights philosophy itself. So that is really the ultimate question with which Phil's book confronts us. The rhetoric of natural or unalienable rights, the social contract idea or the idea of government by individual consent, these are practically built into our native, yours and my native political language. But is there a pure natural rights philosophy that is a philosophy that is the truth, the whole truth, and nothing but the truth? If there isn't, if this isn't so clear at least, then other rhetorical registers of the founders, other choices or practices of the founders that cannot easily be squared completely, purely, perfectly with their natural rights rhetoric, these other choices and practices must be understood and weighed in seeking to determine the design or spirit of the Constitution, including the religion clauses of the First Amendment. In that case, if this is the case, then to befriend, and this is perhaps the best short statement of the thesis I would propose to you, if it's the case that the natural rights philosophy is not only the truth and the whole truth, in that case, to befriend, to be a wise friend of the religion-friendly natural rights republicanism of the founders, it would not be sufficient to embrace the pure idea of Lockean natural rights. Now, what is the essential premise, the ultimate foundation of the unalienable natural rights argument? I commend to you Phil's chapter 2 especially. That foundation is the self-evident truth, the proposed self-evident truth that all individuals are created equal. What this means is that, as Phil rightly interprets it, I think that no man is by nature the rightful ruler of any other man. In other words, again, that is native to us. It sounds reasonable and good, but let's scrutinize it. In other words, what this implies is that the wise and good have no natural authority over the ignorant and vicious. Or, in Phil's words, men are equal in their natural dominion over their own lives. There's a nice, strong statement. We all equally possess a natural dominion over our own lives. Well, this is an invigorating and politically useful premise. I no more than Tony or Phil would want to abandon it. But is it the whole truth? Is it simply true, or is it a useful fiction and rhetorically invigorating position to say that all men are equally, we mean, of course, all men and women, equally competent to govern their own lives? Phil quotes a great professor who happens to be an important teacher of mine, Harvey Mansfield, who says that the thing to which one has a right must be possible to do. That would seem to be inherent in the definition of a right. what we have a right to must be something possible. Well, in the spirit, one might ask, is the supposedly natural condition of humanity possible? Do we by nature possess absolute dominion over our own lives? Do we even know what this would mean? In an absolute sense, do we not, for example, need help from others, from the past, from institutions, from authorities that existed before us? Do we not need help to gain competence in running our own lives? The help, say, of families and churches. And these families and churches would have to exist in a supportive legal environment that depends upon a political community, a community that shares some substance, some moral substance, even religious substance that cannot be derived, I say, from pure natural right, from the pure right of the individual to dominion. In part 1 of the second volume of Democracy in America, Tocqueville convincingly refutes the notion that any individual can produce for himself all the truth that he needs to draw upon in his daily existence. I won't take time to review Tocqueville's argument. But for that matter, James Madison himself, somewhat shockingly, I think, in Federalist 49, counsels against throwing individuals back upon the need for absolute first principles, such as individual dominion, and reminds us, Madison does in the Federalist Papers, of the practical need a constitutional order has for the veneration that time bestows, for habit, for tradition, for a kind of an authority that cannot be derived from the sheer logic of individual dominion. I conclude, too hastily, but I propose to you the conclusion that the pure and absolute natural right of individuals cannot be the whole truth. Every truly philosophical political philosophy involves some view of the whole, some view of the good, or of what a human being is and what human life means. John Locke and the natural rights idea are no exception, though they pretend to be, I would say. The question of the meaning of the whole is irrepressible, and that includes John Locke. Let me proceed, since time is short, directly to the interesting case of James Madison, whom Phil presents in a compelling way as a kind of middle term between, in the religious liberty debates, between Thomas Jefferson, let's call him more secular, and Isaac Backus, whose arguments were straightforwardly religious and Protestant, and Madison stands somehow in the middle. So in a way, the question of the foundation of religious liberty and natural rights republicanism could be seen to come down to Madison's effort to mediate these secular and religious arguments. And Madison is a good example of the fact that the founders do not appeal to reason alone. Of this founding triad of religious freedom, Madison clearly holds the central and pivotal position. If anyone can coherently combine the rational and religious arguments for an individual right to freedom of conscience, that would be Madison. But in a sense, Madison is, you might say, if we're looking at this in terms of the reason revelation question, Madison is neither fish nor fowl, but a kind of fowl fish. Yes, that's it. Madison as the flying fish of the founding, the most high-flying spiritual Lockean, you might say. Madison defends an emphatically individualistic natural rights argument on the basis of a transcendent and inalienable duty to God. The argument is sublime and appealing. Clearly, there is truth in it, even, if I might say, the relish of salvation. But has Professor Muñoz, have any of us really confronted this plain Madisonian paradox, that the self-evident rights of nature depend upon a God beyond any common public rational understanding? And how is this Madison to be squared with the Madison of Federalist 49, for example? Well, my time is up, but you can see by my choice of quotations that I'm proposing that Locke needs a supplement in Tocqueville, and that the idea which is a simple way of putting the idea that the radically individualistic philosophy of natural rights needs a supplement in an idea of human nature that is more holistic and more open to truths that cannot be reduced to pure intellectual or pure individual dominion. And there I will conclude. Thank you.
Thank you. Thank you, Professor Hancock and Professor Peacock. I don't know how much of that was easy to follow for you all, having not read the book. Let me just say that those are two extraordinarily learned evaluations. I mean, there's really nothing more a scholar can ask for than to have other scholars take the time to take your work seriously. So I am deeply grateful. Really, really thoughtful criticisms. I said I did three things in the book. I did a history, I did a philosophy, and then I did constitutional law. And I said the history was, in some ways the least interesting and least important. So they both skipped that. And then Professor Peacock said, well, the book was good, but you got all the law wrong. And then Professor Hancock said, well, the book was good, but you got all the philosophy wrong. So at least the unimportant things I seem to have gotten right. Okay, so let me try to explain what I think is the essence of the criticisms, and then give a very brief response as much as I can. Let me just say again that the criticisms are very good. Professor Peacock's first question is, why are you so hesitant, right? I mean, why spend so much time writing this book only to say you're just trying to explain things? If these things are true, why not just advocate them? And there's a specific problem, in part, I have in mind. So let's just gentlemen, pretend I got everything right. You can just accept it. You guys pretend it. And if I got everything right, then the First Amendment needs to be rewritten. And, for those Supreme Court justices watching, just, read Chapter 8, and this is how you can rewrite it. But here's the problem. If you rewrite the First Amendment according to what I find in the book, what about the Second Amendment and the Fifth Amendment and the Eighth Amendment and the meaning of commerce, which is Congress's power? The Constitution as a whole, and I think the whole Constitution is a natural rights Constitution, but it's not clear that you can simply apply the natural rights philosophy to one part of the First Amendment if you don't apply it to the whole thing. So if I'm right, and then justices said, okay, well, we'll take that and we'll apply it to the First Amendment alone, well, what about the rest of the Constitution? So you have a non-natural rights approach for everything else and a natural rights approach for the first thing, for the First Amendment. That would lead to all sorts of incoherences. So I'm with Professor Peacock. I mean, if you let me rewrite the entire Constitution, we could make it coherent. And then this would make sense for the First Amendment. But it's one thing to be a scholar and say, this is the First Amendment. It's a second thing to think, okay, if the court has got it wrong in all these ways in the First Amendment, and the court has got it wrong in all sorts of other ways, how do we fix that mess? And that's a prudential question. That's what I mean, that goes beyond the scope of the book. So small example, right? Remember the Little Sisters of the Poor case? These nuns who, under Obamacare, they had to buy, if they hired someone, they had to buy them birth control. And the Little Sisters of the Poor are like, we're Catholic nuns. We don't do that. And we have a First Amendment right, they said, to not, to live our faith. I'm very sympathetic to the Little Sisters of the Poor. But if the Supreme Court followed my interpretation, the Little Sisters of the Poor would lose. And so then lots of people say, well, why do you hate the Little Sisters of the Poor? Well, I don't hate the Little Sisters of the Poor. But the First Amendment was not meant to protect them. They are meant to be protected by other parts of the Constitution. But those other parts of the Constitution, the court has messed up. And so the lawyers turn to the First Amendment to remedy the other mistakes that have been made. Everyone following me here? So you got to remedy the whole thing. And that's a very hard project. right? And this is just one book on one part of the First Amendment. So the mess is even deeper than, and the remedy is very hard. Okay. Professor Peacock asked, well, what do you have to go beyond the Constitution? And once you go beyond the Constitution, where are you going to go? I mean, if you tell a judge they can go beyond the Constitution, who knows where they might end up? And isn't that a danger? And the answer is yes, certainly it's a danger. And me saying that they need to go beyond the Constitution to interpret the First Amendment isn't going to make them any more or less likely to do so. I mean, they're going to do so. But the problem is you actually have to do so. The Fifth Amendment protects persons from, you can't deprive a person of life, liberty, or property without due process of law. But who is and who is not a person? The Constitution doesn't say. So we have to think about things, right? And if you go study philosophy at Yale or Princeton, you will learn about speciesism. Species and animal rights. And speciesism means you inappropriately distinguish between the species. Animals are people too, they argue. You have to have a PhD from an Ivy League school to believe this. Or what is the new Google chat thing? Or chat. They're people too, and they have rights. Robotic rights, artificial intelligent rights. I tell you, if you're an aspiring graduate student, this is what you should write about. Well, are they persons for the purpose of the Fifth Amendment? You can read the founding debates and they won't talk about that. So you have to go beyond the Constitution to something to actually interpret the text of the Constitution. The question is, if we're going to go beyond the Constitution, where do we go? And my answer is, well, we should go to the natural rights philosophy that clearly was the animating spirit behind the Constitution. To interpret the letter of the law, we have to understand the spirit of the law, basic argument. Okay, so that's my response to Professor Peacock. Now, Professor Hancock says, but the spirit of the law, that is the natural rights philosophy, is at best a half-truth. And that is a long argument, at least responding to it would be a long argument. The essence of my response is, I don't think natural rights are nearly as individualistic as you suggest they are. So in many ways, I don't disagree with any of your criticisms, but part of what the book is trying to do is show that natural rights are far less atomistic, at least in the founder's understanding, and far more communal or republican than we believe. So it's not really the disagreement is maybe we have different understandings or interpretations of natural rights. Let me use, maybe I can explain it this way, right? To say that we have a natural right to religious liberty doesn't mean we don't need churches. It doesn't mean we're all left to figure things out all on our own, right? It's not atomistic. To say you have a natural right of religious liberty just means that the government can't compel you to go to church or punish you for going to church. But should you go to church or not? Well, you need all sorts of help to think through that. And who should help you make that decision? Well, I have 3 kids. I have a 10-year-old, a 9-year-old, and a 5-year-old. Well, the first people that should help my children make that decision is their mother and their father. And as much as I like the governor of Indiana, if he tried to make that decision for my children, we would have an unhappy situation. So that natural rights philosophy is not against families, and it's not against churches, right? The other people I want to help my children are the teachers at their religious school and the priests who lead their Sunday school classes. But this is all part of the natural rights philosophy. The natural rights philosophy is about what the government can't do to you. It's a way to let us govern ourselves. And in governing ourselves, we learn of our mutual dependence and need for one another. So I don't think it's as nearly atomistic as many people think natural rights are. And so one of the underlying aims of the book, and this is especially in chapter 3, and I was actually very pleased that in chapters 2 and 3, that Professor Peacock and Professor Hancock mentioned those chapters, is to explain to the American people what our natural rights are and how they allow for community, how they allow for us to govern ourselves together, right? I'll close on this. I'm probably the only person who teaches a speech by Herbert Hoover. The fascinating speech that Herbert Hoover gave, I think he gave it in Madison Square Garden, believe it or not, in 1932. And he's talking about, the title of the speech is The Consequences of the Proposed New Deal. FDR was proposing the New Deal. And FDR, Herbert Hoover, who was running against him in 1932, said the New Deal will have all sorts of deleterious consequences. And the main consequence it would have is it would destroy the American experiment in self-government. What Herbert Hoover said, I think, is true. The genius of American republicanism is it allows the American people to govern themselves outside of the government. It allows the American people to govern themselves together outside of the government. It's Tocqueville, right? That is Tocqueville. And that is our natural rights republicanism. As difficult as it is to attempt to reinstitute that into our law, if we don't understand that natural rights republicanism, we can never recapture it. I thank you very much for letting me share this time with you.